Then our next case is State versus Valentino. Each party will have 15 minutes to present the argument. Counsel, how long would you like for rebuttal?
If I could just preserve half my time for rebuttal, Your Honor.
What's that?
Half my time for rebuttal.
I think our maximum is 5 minutes, so we'll reserve 5. I'll be keeping the time up here. I didn't mention this last time. So when you get to about a minute left in your time, if that's the case, I'll let you know that you have a minute left.
Perfect.
So you're aware of that. The arguments are being recorded. When you come up, please introduce yourself for the record. Please stay behind the podium so the video can pick you up. And please speak loud enough so we can hear you when the court's up. Video can hear you as well. If you have any children, minors, and victims or anyone like that to refer to, please use initials or some other designation rather than their names. Having said that, we've read your brief and we're ready to proceed whenever you are.
Your Honors, may it please the Court, my name is Pierce Walker. I represent the appellant in this case, Nicholas Valentino. I was also trial counsel on this case. Your Honors, I'm going to dive right into our 2 assignments of error. Specifically the first, I think this issue is very simply resolved under the first assignment of error. Regarding the sentencing, regarding the terms of probation, the only appeal that we have is regarding the terms of probation in this case, alcohol and drug use. This was a telecommunications case that resulted in a plea deal in which my client pled to telecommunications harassment with the other charges dismissed. The other charges being a menacing by stalking and an additional telecommunications. So only one telecommunications harassment misdemeanor, and we go to sentencing in this case. Respectfully to the state has, I believe, a policy in Medina App.No that they do not go to the sentencing. So the state was not present for sentencing whatsoever, therefore had no opinion or comment or objection therein. When it comes to the reasonableness of the terms of probation, my objection is that there is no relationship between drug and alcohol monitoring and a telecommunication harassment.
I have a question.
Yes, Your Honor.
Your brief says there was a no contest plea pursuant to a plea agreement?
Correct.
So was this an agreed upon sentence?
No, Your
So
Honor.
what was the plea agreement?
The plea agreement was a dismissal of the 2 charges with that the state would remain silent at sentencing, Your Honor.
Okay.
And so my understanding was obviously they didn't show up, so that is them honoring their end of the deal, they remained silent. We also knew that he had been in for quite some time at that point when we did the plea, so we weren't overly concerned with what are the terms and how much time, and we never had any conversation about drug and alcohol monitoring.
Was there a PSI?
That's an interesting point, Your Honor. I asked to see a PSI, and respectfully, and I just want to be honest about my appeal, I did not put that in my appeal, but because it was a question provoked, I never got permission to see the PSI in this case. I asked to see it from the judge. My understanding was he had a PSI, he referred to it, I asked to review it. In my entire career, I've never been told no, that I can't see a PSI.
So, because you quote things too, like the police report, is that part of the record?
It is part of the record in the sense of when the court asked for me to brief my concern and my objection, which I made on the record, I objected to drug and alcohol use, and the court had indicated, please brief it for me as to what my concern was, and that is directly related to prongs 1 and 2 under State v. Jones, and that is there is no relationship with the facts that would require drug and alcohol be monitored.
And you also assert that your client had no criminal record?
Correct.
Is that part of the record as well somewhere?
It is, in my understanding, when we went through the actual discovery that we received, and I received the leads on my client, there's no history of criminal history for him, minor traffic tickets, but as to any misdemeanors or felonies, he has no criminal history. When it comes to my concern is, we're looking at an email, the facts, which is what we briefed, there's an email that my client sent, and obviously he pled no contest to, and so therefore we assume the facts are now deemed admitted, but there's an email that causes telecommunication harassment. There's no concern. One of my concerns in this case is that in the discovery, there's a concern of mental health, and I raised this in my brief, that if the trial court found that because there's evidence of mental health that they're going to order mental health treatment, I can appreciate that, and that would fall under prong 1 of State v. Jones, that it would have a connection to that. That was never raised, it was never a concern. I do want to address something that the state raised in their brief, and that is that there's this invitation by my client for the victim, J.N., his wife, to appear and make a statement. As this court knows, Marcy's law, we don't invite victims. Victims have a right to make a statement under Marcy's law. I can't invite or disinvite, as a counsel for a defendant, that a victim can appear or not appear. Whether she makes a statement or not is her choice under Marcy's law.
So if the victim in the case says there's a drug issue, that's not a good enough connection?
Well, and I appreciate that, Your Honor.
And then one more thing I want to add to that. If you have a victim saying that in conjunction with potential mental health issues, couldn't the mental health issues potentially be really a drug issue?
I completely agree. The problem is, Your Honor, that's not in this case. That's not the facts in this case. So when we see kind of a blanket, I have concerns about mental health, it could be a wide variety of things. The gambit of mental health, as we know, is vast. So is it drug and alcohol? We didn't know.
So you think the proper thing, not ordering alcohol, it would be to assess that situation? Is that what you're saying on probation?
I think that could have been an option the court should have taken. I would not have appealed. If the court had said, I want to do a mental health evaluation and then go from there, and if that led to additional testing requested by the court or by the state, I don't think I could have an objection under a good faith basis to appeal it. My concern is that that wasn't there. So what we see is we get to a sentencing, we have a victim appear, make a statement, and assume and brings in facts that were not presented in the case. And that's what goes to my second prong. I still think, though, Your Honors, that this case is resolved under the first assignment of error. That under State v. Chavez, which this court, this 9th District has actually dealt with a bad check, that the facts of the underlying crime have to relate to the probation. If we're looking to help defendants actually get rehabilitated, that we are trying to avoid them committing future crimes of what they just did, it's not just future crimes in general. We're not trying to avoid an OVI here. We're not trying to avoid a possession charge. We're trying to avoid additional telecommunication harassment. How do we do that? What are some terms we can put in there to help him? Drug and alcohol monitoring, when it's half of the terms of probation, it's nonsensical how that would apply under this court standard of State v. Chavez, which interprets State v. Jones.
Counsel, let me go back to an answer you gave to Judge Lanzinger, and that was pertaining to, because I'm trying to understand what should or should not be terms of probation. What you said was that it may have been okay, and you wouldn't have appealed if the judge had said, we're going to get you evaluated for drug and alcohol. If there's no indication that drugs and alcohol were involved in the crime, and that seems to be like the test that you're using, because you say it has to be connected to the individual crime that the person committed, why even have an evaluation? Why would that be okay? I guess I'm not understanding, because the point is, if there's no evidence that it was connected to the crime.
And Judge Carr, I apologize if I misspoke. I thought my answer to Judge Lanzinger was dealing with mental health evaluation. That if, because in the actual discovery of the case, there was an allegation of mental health raised by the victim, JN, that if the trial court found to do a mental health evaluation, that'd be very different than doing a drug and alcohol screening assessment. And so if I misspoke, I do apologize. My answer I was trying to clarify was, if the trial court had said, we see mental health in discovery, I want a mental health assessment, no objection. It relates. I wouldn't appeal. I would tell my client I don't have a good faith basis to appeal. That wasn't what was done here. There was no mental health assessment done or requested by the state. Rather, we go to sentencing and we see the trial court made comments about half of the probation is drug and alcohol screening, and we're trying to understand how it relates to the crime.
I hate to point out, but substance use disorder is mental health, right?
Right, and that's what we talked about, right? Mental health assessment, the gambit of mental health assessment is vast. Do I agree that drug abuse could be a mental health component? Absolutely. It's an addiction that goes to mental health. But then again, I'm not a professional to speak on that. I just know that the scope is vast. But that's not what was done here. Instead, what we dealt with is, which takes us to the second assignment of error, is the trial court, when I made my objection, offered the chance and requested that we brief it, which we did. And in the response by the trial court, which was unopposed, my brief was unopposed by the state, the court relied upon the victim's statement at sentencing, which is why I invoked the statute 2930-14B. And that is, if you're going to have a victim impact statement read or made during sentencing, and there's going to be new evidence brought in, we should be afforded the chance to either have the hearing continued or be afforded the chance to respond. And again, I would be remiss if I didn't make an observation in the state's brief, and that is this comment as to what my client, when he tried to speak to that issue after the victim impact statement was read, the trial court denied him. The insinuation of what he was going to say I find to be improper. We don't know what my client was going to say because the door was shut. We don't know what I was going to say because the door was shut. So if you're going to allow victims to come up, it's a slippery slope in the criminal justice system.
We have about a minute of time left, just so you know that.
Thank you, Your Honor.
Did you at any time object during the hearing or in your brief to say, look, we want a continuance because the victim said these things and we want time to present these facts to you? Did you include it in your brief? When you filed your brief afterward to say the victim said X, we're saying Y about it?
Absolutely, and that is, Your Honor, how we brought in the police report, is we try to show the trial court that this has never been raised, that this actual reporting victim to this specific police officer over 5 times never said any concerns of drug and alcohol use. So where are we getting it from? It's newly discovered evidence, we get the chance to respond. It's a slippery slope if we don't allow defendants to do so, because now victims can come into court.
But in your brief, did you have that chance to respond to say, wait a minute, this is all new and not sentenced for? So you had a chance to respond in your brief that you filed.
I did, Your Honor. The trial court did afford us that opportunity to brief it, which we did. There's no further questions, I will wait for rebuttal.
I do want to ask you a question, and I hate to take some of your rebuttal time, but this is very important, I think. What is the scope of the appeal that's in front of us now?
Solely the terms of probation that deal with drug and alcohol use. We are requesting that they be removed from his probation terms.
Right, so my point is, you didn't appeal the actual final appeal of order, you appealed the, after you briefed, you appealed the judge's, I don't want to say, his denial of changing the probation terms.
Correct. So we are appealing the sentencing terms on its face, which I think our understanding of the nullity order by this court was to include our brief that the trial court requested.
Has your client already served his full probation term at this point?
I don't believe he has, Your Honor. I think he was sentenced to a year. You caught me off guard with that question. I would have to check. I believe he was sentenced to a year probation, and he'd be coming up on it in February. Thank you, Your Honors.
Good morning, may it please the court, my name is Megan Philbin. I represent the appellate of the state of Ohio in this appeal. This appeal arose after Mr. Valentino had entered a plea to 1 count of telecommunication harassment under Ohio Revised Code 291721B6, and he was sentenced to probation with condition of no alcohol or drug abuse. So there are 2 assignments of error, I'm just going to go through each of those. The first assignment of error is whether the trial court had erred when it issued its sentencing in probation terms of alcohol and drug monitoring. And Mr. Valentino contends that the condition of no alcohol during his term of probation had nothing to do with the original offense. So, both the state and the appellant has cited the same cases, State v. Chavers, which also was citing State v. Jones, to determine, what the test is and determining whether or not this is an appropriate term of probation. So, the first issue is whether the condition is reasonably related to rehabilitating the offender. And I'm going to just connect it with a third as well. So whether the condition relates to conduct which is criminal or reasonably related to future criminality and serves the statutory end of probation. So in the Chavers case, that was also a similar term of probation, a condition against consuming alcohol. And the Chavers case indicated that that condition met the first and the third prong. So really the only issue in the state's position is whether the condition has some relationship to the crime. So appellant's not incorrect in stating that the incident itself did not deal with alcohol specifically. There was no mention of alcohol at the time of the incident. However, where we get this issue of drug or alcohol abuse was from the victim when she identified it in her victim impact statement. So actually the victim's initials are JV, it's the defendant's wife in this case. And she indicated in her written victim impact statement, which she provided to the court prior to sentencing, the same thing that she had identified on the record during the sentencing, which was...
Is that written victim impact statement part of the record on appeal?
I don't believe so, Your Honor.
It's a PSI. Was there a PSI in this case?
I believe there was a PSI. They did obtain a statement from the victim in this case. They did attempt to, I believe, question the defendant, and that's on the record from the sentencing hearing. They sent him questions to participate in the PSI, and he did not do that in this case.
Is the PSI part of the record?
Your Honor, I'm not certain. So the victim identifies in her victim impact statement and in open court that Mr. Valentino had these issues with drug abuse, and the court then put that as a condition of probation, that he not use drugs or alcohol. And it's the state's position that there is a close connection between drug abuse, alcohol abuse, and mental health concerns that it was proper for those to be connected, and that's to be a term of his probation here. So the state's requesting the first assignment of error be denied. But it's closely connected to the second assignment of error here as well. So we're dealing with the same issue of what happened during the sentencing hearing. And part of that is whether the trial court had erred when it relied upon the victim's statement during that sentencing hearing. Now, Mr. Valentino does complain that the victim, JB, her statement during the sentencing hearing identified new material information, and the court was required then to continue the hearing or permit Mr. Valentino to respond. However, Mr. Valentino did not object to her statement at the time of the sentencing. He also did not ask for a continuance to respond to that as well. The state does mention in our brief that Mr. Valentino had identified the victim was going to speak on his behalf. So part of the state's argument is that this was somebody he had also requested to speak on his behalf, and then after the fact he was saying what she had indicated to the court was something new and surprising. So this was after the victim had also previously submitted this lengthy written victim impact statement to the court, and it had matched up to what she had said during this hearing. So the information that's on the record from her speaking at the sentencing was that she had found drugs in the family home, and it was not new or material as it had been previously identified to the court. I already indicated that Mr. Valentino did not object to her statements during the sentencing. He only objected to that imposition of the condition of probation of no alcohol consumption during probation. And the state's position, we have a portion of the transcript where Mr. Valentino attempts to speak to the court, and he identifies that as the moment he was trying to object to what the victim had said, but that was in response to the judge indicating to him, to Mr. Valentino, that he had not submitted a response to the PSI, to the questions that the court was asking of him. So he did not participate in that, and the court was addressing that issue with him. So it's not a matter of the trial court not permitting him to respond to the victim. The court did permit Mr. Valentino to respond to the objection to the term of probation, and the trial court asked Mr. Valentino to do that in writing, and he did permit Mr. Valentino to object in writing. So state's position that this assignment of error should be denied as well. I know that there's a question that Judge Carr had brought up about this appeal being a nullity, and it's the state's position that this appeal is of that trial court's decision and not of the sentence itself. So it's the state's position that Mr. Valentino is appealing a nullity because I believe I had cited it in the response to the court requesting us to brief that issue. But it's the state's position that this decision was a nullity, and I would ask that these assignments of error be denied and that the trial court's imposition of the sentence be upheld in this case.
Counsel, before you sit down, I just had a question in regard to the state of the law in this area with probation conditions and so forth. I know, and it was many, many years ago that I was a trial judge, but I don't remember ever issuing a probation, in terms of probation, it didn't include abstention from alcohol and drug abuse. Obviously, you can't have drug abuse because that's illegal, so
Right.
that's not a problem here. But what about the alcohol? So is that pretty standard, would you say?
Yes, it is, Your Honor.
That's my question too. What specifically does the order say about alcohol and drug? Is it you must submit randomized testing, or is it monitoring where there's affirmative? Because to me, it's standard to have randomized testing during probation, but is this more specific than that, or more burdensome?
Your Honor, I'm not exactly certain specifically what it says in the trial court's order. I do know that generally the court would do monitoring, and they would be subject to random screens. So that's as far as I know what the court usually does with sentencing, but I don't want to misspeak. It would be in the record in what was submitted of the trial court's sentencing entry. Thank you.
Thank you.
want to respond, if I can, Your Honors, to the first issue of whether or not this is a nullity. Appellee's brief indicates that there was an objection to the trial court's probation terms, and so it's somewhat deemed as a motion for reconsideration. The state cites a case, State ex rel adopted the handwork. It was not an objection, it was not a motion for reconsideration. When we made the objection on the record, the trial court offered us the opportunity to request for me to put into a brief. So when it comes to whether or not it's a nullity, when the trial court opens the door and requests briefing on an issue, I believe it remains open, so I don't believe this issue is a nullity.
So you're saying that ordinarily the sentencing entry would be final and the court would lose jurisdiction, but here the court was basically still, you're advocating that it was basically still an open decision and was not final because he had requested briefing on the issue?
Absolutely, that's absolutely exactly what happened, Your Honor.
Did the court issue an order on the day of sentencing? Or did the court wait to issue its order until it heard on your brief?
My understanding was he waited until after our brief because his ruling came, I believe, within about 24 hours of my brief being final, and then we received the sentencing memorandum as well as the judgment entry denying our motion. I want to address a concern that I have from a comment and a question raised by Judge Carr about whether or not drug and alcohol screening should be on every sentencing memorandum. Screening is different than having to be a term of probation. When there are 4 out of the 8 terms are solely dealing with drug and alcohol testing, randomized testing, screening, assessments, abstaining from any establishment that serves alcohol, what does that have to do with sending an email? How are we helping a defendant rehabilitate from an action of he's not controlling his language, he's not controlling his actions towards communication? None of that has any connection to it. So,
Well, I guess that was my question. Is it, you're on probation and everyone's subject to randomized testing, or was there more to this order, like you just said something about not being able to go to an establishment that serves alcohol?
yes, Your Honor, I think our brief goes through, I think, all the terms that we objected to that are in it, so we would obviously resort to our briefing, but there was extensive components of probation terms of abstaining from any establishment that serves, random testing, monthly testing, an assessment at the very beginning. I mean, it's a voluminous order regarding drug and alcohol assessment. If it's
Well,
gonna
really
be
the
rubber
only,
stamped.
I'm sorry for interrupting, but I wanna make sure, cause I said something and maybe you are, opposing that as well. But I don't think there really can be any opposition to the drug abuse, right? I mean, because you can't use illegal drugs if you're on probation.
Well, marijuana is legal in Ohio, so.
Well,
we
I
then have
understand
concerns
that, but it
people are
talks
gonna
about
find that
controlled
testing.
substances.
Correct, controlled substances I completely agree with, but I think it's a very dangerous order to say that all criminal probation should have drug and alcohol components to it, because it falls under mental health. No judge that I understand also carries the certifications to qualify mental health to say drug and alcohol abuse should be applied to all mental health. So I think we have to be very careful in saying that. I don't think that there's any statute that permits the judges to do so at a sentencing hearing. My
Well,
concern is
if
it
there
has
was
to relate.
anything that gave guidance to the judge regarding these issues, it would have been in the PSI. And we don't know if there is or isn't a PSI record. From what I understand from you, that it seems to be there's a reference by the judge who have reviewed a PSI.
Correct.
But we don't have that PSI in the record before us, is that fair?
Correct, and I never saw it, Your Honor. So I also asked to see the PSI. I never saw the victim impact statement. We ran into sentencing, and when it comes to the drug and alcohol assessment, I don't understand the causal connection on any of the prongs under state v. Choppers and how they relate.
You have a minute to rebuttal.
Thank you, Your Honors. I also want to end though, when we're dealing with how do we truly sentence, I think we have to be more careful and use discretion a little more specific to each case and not have rubber stamps. I think we can't say all mental health, if there's a concern about mental health, just throw drug and alcohol in there, because somehow that always relates to mental health. I think that's dangerous.
But doesn't this order also talk about an assessment as well?
The assessment is the initial part, but then disregarding the assessment, we're still going to apply all the terms. So it would be different if the trial court said, I want to see an assessment and we'll follow the terms of the assessment. We don't have that. We have a victim coming in who is also going through a divorce that says, here's my soapbox of why I have an issue with this defendant, throws in drug and alcohol that's nowhere in the facts, which the state just conceded. It's not in the facts of the case.
Going back to not having the PSA, how do we know there wasn't an assessment done before sentencing at some point, where the judge has that information?
And I think my response, Your Honor, would be that's the trial court should have disclosed it, so that I could then, I can speak to this PSI as well, which I do at every sentencing I go to. I review a PSI, I have the chance to talk about the highlights of the PSI, and to address any negatives. I wasn't afforded the chance to see a PSI, and respectfully, it wasn't part of my appeal. It's solely pertaining to the drug and alcohol screening and assessment should not be part of the terms of probation.
Thank you. Your
Thank
time.
you, Your Honors.
The court will take the matter under advisement and will issue a decision in due course. When that decision is released, it will be mailed to you by the clerk of courts. It will also be posted on the High Supreme Court website. With that, I'd like to thank both of you today for your presentations on behalf of the